This will stop when everyone makes it stop. What are you prepared to suffer?
Hey guys, Gavin here again, Sovereign Empowerment, and I'm joined by the man Damian. We've got about an hour on this one, and what we're going to focus on is, remember the last one we talked about Damian's success getting a school PCN pulled from the court. He's replicated it. Slightly different, but he's replicated it. So we're going to go through that. But there's bigger implications to this win, because what Damian's done applies to all PCNs. This would either include ULEZ fines as well. So what we're going to do is explain what's just happened. Then we're going to put that into a format, or Damian's going to explain that in a format of how you would apply that to all aspects of PCN fines, but equally, all aspects of how you would litigate against a public authority or individual within the public authority. Because remember, we don't go after corporations, we go after people. And then there's a big thing here. We're going to have a link in the description after this. Now, what Damian has been able to obtain and what we are going to share with you folks is a document that will contain every single act that binds the public servants to their statutory duties. That's gold dust, guys, and hugely beneficial to you guys litigating against these people. So that will be in a link in the description. We'll provide that to you guys. You can download it, go use it. But with that said, Damian, welcome back, mate. I've obviously heard about this win, but I'm very excited to hear really what's happened, how you've done it.
It's persistence, Gavin, and hello to yourself and all the wonderful viewers. Yeah, it's persistence. Look, when you come from a foundation of truth, you understand the law, you understand due process, and this is really important because the councils, the local authorities, limited, delegated. You've got to remember that the legislation limits their power, and their power ultimately is derived from us, point A to point B. And this is the beauty of this law journey, because it gives you a complete understanding of seeing how they behave and how they act. We have due process, which is how the law is supposed to work. It's certain conditions, certain provisions protecting our rights, and how perceived authority is supposed to behave in lawful matters. Now, unfortunately, these councils, and unbeknownst to a lot of the parties there, they take you through an administrative legal simulation. Now, when you understand the law and law processes, you're not going to be hoodwinked by it. So you do what I do, which is just catalogue everything they do from point A to point B. Point B is when you've brought it to its natural conclusion, i.e. justice. So they decided they weren't happy with my letter, the school. So the assistant head there escalated it against his better judgment and against me explaining the law to him. But you've got to understand, when I write to these people, I couldn't give two monkeys what they do, because I will just catalogue for my case file, my legal memorandum, what they do from the beginning to the end. And the end is when I brought it to its natural conclusion, and then when I sue them for damages, because that is now my next step. I brought it to its end, its natural conclusion. And the end is the council were unable to obtain money from me with threats and menaces and attempted extortion, which was pointed out to. I'll read through the final letter that I sent them. It was a cease and desist legal simulation notice, where they realized that actually I'd set them up over a 2-month period. So did I lose any sleep over this? No, because I've been through this process and I was just cataloguing all of their crimes, right? Their breach of Article 12, the Bill of Rights, 1688 and 89, right?
Just a quick one, just to clarify that, because I know there will be some people out there that know about that, have tried to use it with PCNs and it hasn't worked for you. So I just want you to understand. So that what Damian's referring to is the part of the Bill of Rights that says All grants and promises of fines and forfeitures before conviction are illegal and void. Something to that effect. I think that
Right.
is actually how it says it, isn't it?
Yes, it's having the confidence. Now, it's how in law, it's how you articulate the argument. It's how you evidence your findings and you support those findings. Okay. I left them in no doubt. They couldn't take this any further. And I'll explain it. I'll tell you, before I take this any further, look, I'll read out this letter that the team manager at the Inclusion and Attendance Service, a division of the Children's Services at this district council, she was sent after previously telling me that the Bill of Rights had been repealed by the Statute Law Revision Act 1948. Okay. Now, I read that back to front. Now, first and foremost, we know the Bill of Rights hasn't been repealed, and there's a reason for that. They can't repeal it. Parliament posture, right? And media erode your confidence in it. But I have read, because I have access to a VLEX Justice account, I have read more case law regarding the Bill of Rights in the last 3 years than you can shake a stick at, but they won't publicly disclose this. They don't want you to know you're right. You'll have to bear with me because there is a statement within there that's very, very important. The Bill of Rights as a declaration states that what is enacted therein shall stand, remain the law of this land forever. I'll say that again, that what is enacted therein shall stand, remain the law of this land forever. It's the law of the land. Okay. And all the articles within are your rights codified into superior statute. And there is a hierarchy of statute that the House of Lords, the judiciary, the lawmakers will recognize, and they can't be expressly or impliedly repealed. So anyway, this Egypt, having taken legal advice, came back and said that the Bill of Rights had indeed been repealed, basically saying they can do what they like. I'm like, no. You can't. You haven't read that act, have you? I've read it. And it states, as it does at the bottom, if you go and Google legislation and go to gov.uk with regards to the Bill of Rights, it says at the bottom, 2 textual amendments. And I'll tell you what they are. That isn't a repeal. That isn't making the Bill of Rights void. What they've done is they've changed the old spelling of Parliament from the old language in 1688 to the new language, to now. Okay? It's an updated word, a change of spelling and structural grammar. They're the 2 textual amendments. And it hasn't repealed the Act or the Bill of Rights in its entirety. And it hasn't repealed or voided Article 12, which I rely upon. That was explained to. So she was left with egg on her face.
What's that on your face?
So I'll read this thing. But that's important to note that this remains the law of the land forever. So I put here, because I received this after explaining that from the school, I got a formal warning of a fine letter, which I explained, that's a promise of a fine, I hear you say. That's in breach of Article 12 of the Bill of Rights. That's a civil rights violation. Are you trying to violate my private rights? Oh, you're in trouble. I know how to enforce those. Damages, nice. Okay, keep it coming. So just keep those exhibits coming.
Yeah, just keep it coming.
I'll put them in this nice folder, this case file, and all written communications between ourselves, because they're not just going for your benefit. I'm going to be putting these under a judge's notice in the future. Okay? So you're setting these people up, give them a bit of rope, and they bloody hang themselves.
Can I just say something, actually? I just want to because I'm smiling because I read Damian's paperwork. And one of the things I love about what he does, and I think this is also part of why the success comes in, is he's saying this now. He tells them this in his correspondence. So he obviously he knows his stuff very well. So he'll literally tell them what he's going to do. And then what they're doing is just being retained as evidence for the memorandum for the case, blah, blah, blah. And then what happens is, as it comes to a conclusion, all he's done is told them exactly what he was going to do at the very beginning. It's quite funny you see, when they capitulate.
It's come to its natural conclusion where they've gone, oh my God, they've had a realization that I've set them up the entire time.
You set me
Oh
up.
yeah, set you up, of course.
And that their threats, menaces, attempted extortion, their coercion hasn't worked. I haven't lost a second, a wink of sleep. I've just laughed at every communication because their ignorance is their folly, their ego, their undoing, their stupidity, their downfall. Okay? So like I say, you just collate the evidence. So finally, I was issued with it. That was back in, that was the beginning of last week. So that was the 15th of April, which is a section 444A Education Act 1996, which, by the way, I'd already proved with the local court, the school, and because I was a month ahead of them with putting in freedom of information requests, I knew exactly what they were going to do and how they were going to play it. So I was a month ahead. This was fun. The whole process has been fun. And neither the school, the council, or the judiciary were able to provide me evidence anywhere where in the registration process, Section 434 of the Education Act, where I have agreed to the terms and conditions of the Education Act in the registration process, or handed over power of attorney, my son, or agreed to be criminally liable for charges under Section 444. No evidence. None of them can provide me any evidence. This is how you do it. You set these people up. So they're putting it has been noted by this specific authority that you have not made payment in respect to the penalty notices issued to you on the above date in respect of non-school attendance of the following child or children for failure to ensure regular school attendance between this date and this date. The local authority will now consider whether to issue proceedings against you for the offence of failure to ensure regular school attendance contrary to Section 444 of the Education Act 1996. Should a decision to issue proceedings in the magistrates court be made by this authority, you'll receive a summons in due course. So at that point, I'm like, bring it on. I can't wait to flip the court to the rules of criminal procedure. And let's see if you're actually going to push this through bona fide legal proceedings, because up to now, the last 2 months, you've circumnavigated due process with your administrative legal simulation. So they got in reply on the Friday afternoon, because I like to give them a headache, something to worry about over the weekend, like they like to do to us. So promptly at 3:45 that afternoon, so the last thing they see before they bugger off, notice, cease and desist, legal simulation. Gonna tell them what they're doing. I laugh at these people, right? So this went to the team manager and the education welfare officer. Dear Jill and Mrs. O'Farrell, I have received another exhibit from you. A letter dated 15/04/2024 from your department and my private property, stating within this notice that you intended to extort money from me by your administrative legal simulation in the form of an illegal fine. Brackets penalty notice dated 14/03/2024. Contrary. Now they said I was contrary to Section 444. I'm giving them the facts. Contrary to Article 12 of the Bill of Rights, 1688 and 89. That does not supersede this.
Quick one, if I may, just a quick one. That is a classic case of knowing your box, knowing your argument. Damien said this numerous times before, right? And what they do. How many of you are dealing with the councillors right now where you know you're on point with what you've put in and they ignore it? And that's just exactly what they did. They've ignored him, have come back with their letter. So they're just marching on anyway. That's exactly what they do. And then they're bringing in another piece of legislation, which to the uninitiated, you'd end up arguing that fact. You'd argue their point, their box, their argument. What Damien's doing here is bringing them right the way back to his argument where they can't win. Sorry, mate.
No, you're bang on. And I know that I don't have to worry about that because none of them, the school, the council, and the court that they would try and railroad me through were not able to provide me evidence through the Freedom of Information request proving that I'm bound by the terms and conditions of that act. So that's already out. Look, forget what you're saying. You've not provided evidence for your claim. So I'm not party to that. That's for you guys, not for me. But they're party to Article 12 of the Bill of Rights, which they contravene. This letter, brackets notice, is now an exhibit in any future litigation for this violation of my civil rights. Now, civil rights don't just pertain to our black brothers and sisters in the 1950s America. They're for everyone. Okay? Forget color. Forget labels. We're all the bloody same, right? When you understand that our soul inhabits this vessel, our property. Now, this skin that I wear is like wearing a pink jumper, okay? My black friend is wearing a black jumper or a dark brown jumper. My Asian friend is wearing a yellow jumper. But we're all the fucking same inside the jumper. When you get your head round that, you'll see life very differently. Okay, sorry, I've digressed. Civil private rights, violation of my private rights. I will remind you how extortion is defined in law. Extortion is the crime of obtaining something for someone, especially money, by using force or threats. You have followed up your threats with more menaces, threatening possible court action, which are further rights violations. Tell them how it is, guys. They can understand this. My 9-year-old son can understand what I'm saying. Okay? Now I will explain as a paralegal how this so-called fine is unlawful. There is such a thing as due process. Side note, it's in a common law statute, observance of due process, dating back to 1368. It's unambiguous, it's written, and so it shall be. Due process, which has been circumnavigated at this time, means they've gone round it. And fundamental rights belonging to the people codified in superior constitutional statutes. It states in one such statute, namely the Bill of Rights, 1688-89, that for the record has never been repealed. It cannot be repealed, as it is the law of this land, that all grants and promises of fines and forfeitures of particular persons before conviction are illegal and void. I will interpret that for you. It means that only a court can issue a fine. It is my understanding that Jill, Blah, team manager and now liable, and her department, titled the Inclusion and Attendance Service, is not a court of law. Am I correct? In your previous communication, Jill, dated 26. So you're logging down the dates because I intend to put this in front of a judge later on. So I'm being meticulous, and they will have seen this, having sought more legal advice. Oh my God, he set you up. This is meticulous paperwork for a reason. So it corresponds with all the communications, the correspondence in my case file, my legal memorandum that I'll put before a judge. This is what jurisdictionary teaches you, that organization of your case files. Email dated 26/03/2024, you stated that the Bill of Rights, 1688-89, had been repealed by the Statute Law Revision Act, 1948, Schedule 1, which you then provided no evidence for, and obviously hadn't taken the time to read it. If you had, you would have known it was a ridiculous and foolish claim, as that particular act has made 2 textual amendments to the old language spelling and grammar used, and has not repealed or changed the provision enacted within Article 12 that I rely upon. I have subsequently had to send you a Freedom of Information request dated 05/04/2024 to address that particular issue, i.e. no evidence stated above, for clarification for my case file and legal memorandum should I file a claim against yourself and the assistant head, and then I've said the school name, whom initiated these illegal proceedings. I will warn you that should I file a claim into the High Court against you both, I will be contacting your indemnity insurance provider, which I've also FOIA'd for, by the way. I preempted that. So I sent a freedom of information request to get both the schools and the council's indemnity insurance provider. And this is what terrifies them. And this will more than likely push up the insurance premiums for I'll say it, for Lincolnshire County Council and the school, or make both parties uninsurable, which could cost you your employment as well as the personal costs relating to damages. Now, think about the power in that. If they've got to explain to their head of department how they pushed up the entire council's insurance premiums, just because I've sent a copy of the claim to their insurance provider. And think how high insurance premiums are at the minute. And the reason they're so high at the minute is because they can't hide the body count at the minute. So you've got all these deaths.
Be careful of how you say it on this one.
Oh, of course, you've got all these deaths. No, I'm just, this is because my car insurance premiums, and bearing in mind, I'm 50 this year. I've had no claims forever. I drive like Miss Daisy, clean license, and they go down every year to the point that I was £200 a year, which is nothing really. It's about 19 quid a month. Suddenly it went up to 500. I'm like, what? It's supposed to go down. How does that work? Been going down every year. They couldn't tell me. And I found out what it is. These insurance companies think about the 10,000 excess deaths every month. Most of those are young, fit and able-bodied people aged between 20 and 50. That wasn't happening before a certain medical intervention came onto the scene. Your viewers are awake, right? Who's footing the bill for that? The insurance companies aren't. So they pushed up the premiums on your car insurances. That's why, because they've got to cover these life insurance payouts. Think about it. Which is why somebody like me with a clean license forever, right, drives like Miss Daisy, 50 years old in that perfect bracket that they love to insure, whose premiums go down every year, it's only gone from 200 to 500 this year. They've got to cover the life insurance payouts for all these young men and women that suddenly died suddenly. Really? Okay. Why is that happening? It's insane. You could think the last thing these people need is having to explain to their head of department or the CEO or the CFO at the county council, you pushed our premiums up. You're out the door. They don't like it. So I think this is a three-pronged attack, and I'll explain. So you've got that, and then at the end, I have given you every opportunity to stop causing me harm with malicious communications and administrative legal simulation. Call it out. This is what you're doing. Like, I can see it. I'm not a mug. Stop mugging me off. What you're doing is a legal simulation. Right. And require that you cease and desist immediately from hearing. I would also remind you that should proceedings start within the magistrate's court, I have the head of legal's contact details there. And as it would be a summary conviction, where it comes with the knowledge of the rules of civil and criminal procedure, as it would be a summary conviction. So I'm telling them how it's going to be. At no point am I not in control of this situation, born out of knowledge, right? Fear is lack of knowledge. At no point was there any fear or worry. I was completely in control and just cataloguing from point A to point B, right? As it would be a summary conviction, which is criminal, then the rules of criminal procedure come into play. And I would have both CPIA, I will explain what that is. That's the Criminal Procedure and Investigations Act, 1996. It's what they're governed by, and common law disclosure at my disposal. So their legal advisor is going to go, oh, shit, we've got a problem here. Because we were just going to railroad him through there, or it was going to be a private tribunal. They were going to do the old council tax, do the okie dokie down there, you know. Try and bring me into the Butlins gig. Yeah, they railroad you through their own little private tribunal. Oh, yeah, it must be real because we've hired this room in the court venue. So you're going to think it's real. But really, we're taking you to our own private council tribunal. So you're one of our employees. So I'm like, no, I'm just going to flip the court to the rules of criminal procedure. And then I'm going to hit you with disclosure, and you're not going to be able to evidence anything I'm asking. Plus, I've got the head of legal's contacts because I'm a month ahead of you. And I've already forwarded her to death.
Can I just say something? It's also the setup as well, isn't it? So it's like, you talked about multi-pronged attacks. I say this to people a lot. It's getting in those DSARs or FOIAs or whatever it is you're doing, whatever you're working on. You're getting ahead of what they're about to do. And if you're getting ahead of them, this is where the cogs just grind to a halt anyway, because they can't get past, if you've done your FOIAs in the right way, they can't get past what you're even asking them because they know what you're asking for. So there's an inevitable kind of, like you say, there's an inevitable, it just slows down and stops anyway. You give them no choice but to do the action that you're looking for them to do, which is the pulled up thing.
You've got it. And the reason is because on this three-pronged attack, you think the council then contact the head of legal at the magistrates court. And I don't want to touch this. This guy's been driving me nuts. He's forwarded me to death. We're not going to be able to run him. We're not going to railroad this one through the court. He knows exactly what's going on. We don't want to touch it. I'll just finish this. So I put here, so the CPIA and common law disclosure at my disposal, as well as a plethora of litigation tactics, and obviously more damages to come from the named respondents in the long term. You have a choice. Have a lovely weekend. Kind regards, Damian Jones. So,
Lovely weekend.
what happened there? I then got a phone call out of the blue, Monday this week, from the assistant head, who I should be suing for damages, from the school, who said, Mr. Garrett, we've got some very good news for you. The council have come back to us and said they don't want anything more to do with this, and they don't think it's a good idea to assist with this or to issue proceedings. So they put it back onto us, and we've decided we don't want anything to do with it either. So, and because the attendance of the child has been pretty good and I said, stop. I said, I'm going to stop you right there. I said, all named parties have broken the law. I said, that's a fact. And I said, the reason it's come to a halt is because of everything I've addressed in the cease and desist legal simulation notice I sent to the team manager at the county council. I said, so let's cut to the chase. I said, you're liable. And I said, so is the named respondent at the council. And I said, she doesn't fancy it anymore, and neither do you. I said, you've both broken the law. And I said, I should try and find it in my heart to forgive you both and not sue you. So that was the end of that conversation. So I said, but before you go, I said, I want that in writing for my case file and my legal memorandum, please. Thank you. Have a good day.
Has she sent that yet? Just out of interest.
No, that comes through the post. And when I get that, I expected that today. So when I get that tomorrow, I'm going to put that over to you, which you can put up with the video. I'll obviously hide my address details, but I can put up everything that's gone on from point A to point B. You can go up on your site. Please.
We'll do that. We'll do that.
My address data private, so you can see everything I'm saying. I can evidence with fact. But the point is, why didn't they issue proceedings in the magistrates' court? And I'll tell you why. It's for three reasons, which I wrote down, three things that became painfully clear, because she received that and would have read that over the weekend. She's then sought legal advice. This is the county council on Monday morning, to then contact the school at some point, probably lunchtime, to then get the school that is the principal's about to sit down and say, what are we going to do? The council don't fancy. What are we doing? And they're all now they're all clamoring to get away from it, to get as far away from it as they can and take no responsibility. But there are two parties liable: the assistant head at the school, who initiated the illegal proceedings. And he was given 3 communications explaining in law his situation. And I did explain that ignorance of the law is no defense. If you can't claim ignorance, the facts are here. These are the facts in law. I explain that in written communications and verbally.
Just to recap this whole thing now, because what we can do is bring this into sort of PCNs in general and how you would set yourself up for that. So someone's watching this for the first time, someone wants to start learning what to do, right? Obviously, one of the first things we would suggest is the course that we're affiliated with, that all of the big named litigators in America have done, which is the jurisdictionary course, How to Win in Court. Fundamental for the understandings of how you put your case together, right? So there's the one thing, tick that box, you need that knowledge, right? Next thing then is obviously you're going to need to get your head around the Bill of Rights, the Act of Settlement, and the Coronation Oath, but you need to understand the constitutional principles. Now, on that note, what would you say would be the top books to read to just get your head around that aspect? Because it's a key aspect to bring into this. I know we're citing a specific part of the Bill of Rights, and correct me if I'm wrong, because we've never really spoken about this, but the way I would look at that is I want the broader understanding and comprehension of all of the constitutional principles and our private rights so as to
Right.
use it effectively.
I'll go into that actually. That's really good. First and foremost, answer the first part of your question, right? Viewers getting into this, the first thing they can do is print off the Bill of Rights, the Coronation Oath Act, the Act of Settlement. Print them off, read through them again, and then use a dictionary, i.e. Google, and go through the old language and translate that old language, because that's what you need to do. That's exactly what I did 3 or 4 years ago, right? To get an understanding, because your rights are in there. Just looking at the Coronation Oath Act here, look, the people, their spiritual and civil rights and properties. Think about it. So that's your spiritual beliefs. That's your civil rights, civil meaning private, your private rights and your properties. So that's what I would do. Before I do anything, just print those 3 acts off. Read them. Translate the old language. Okay? Then print off from the ratified Bill of Rights. See, 1688 Bill of Rights has the force of law. That's a fact. I don't let anybody tell you different. But 1689 is where it got royal assent and was ratified, even though the original was ratified, but they separated then into articles, each section. And if a public body, a local authority, anybody then breaches one of those articles, so I use a breach of Article 12, okay, which is with a fine. So that can be used with penalty charge notices, fixed penalty notices, as long as you articulate the fact they are fines. Articulate that. If you Google online, you've got the Parliamentary Traffic Committee explaining that a penalty charge is a fine. Okay? That's supporting evidence. That's parliamentary, for God's sake. That's their transport committee explains. And it also explains that the local authorities will be sued if they continue to try and use semantics on words, basically. It explains that. I think that was back in 2005 or 2009. Secondly, before I answer the second part, why did they back off? Why? I'll tell you why. The first, it was outlined very clearly. That was 2 pages, a 2-page letter, right? Civil rights violation. It was very clear that I've got a lawsuit there using Article 12, breach of Article 12, the Bill of Rights, plus I've catalogued the criminal elements, extortion and malicious communications. Yeah, that's the first thing. Secondly, I've hit their indemnity insurance provider.
That's a big one, guys.
Massive. So that would ultimately cost them their jobs. Now, think, she's probably on 60K a year. Nice pension. I've done the background work on her. She served there 29 years. Does she want me eating into her pension for damages? 3, the magistrate's court. I've evidence that I'll flip the court to the criminal procedure rules. I've evidence that I know the disclosure rules under CPIA 1996 and common law. Okay? And I'd also have used the Freedom of Information Act to prove counsel court collusion when I FOIA'd them and have them give me every email and recorded phone call conversation, and they're always recorded between the counsel and the court relating to that case reference number. You've got that, all information held. Now, do you think they want to give you that? That alone would have faces thrown out when they're like, oh shit, what if we said we can't disclose that? We can't give him that. We'll pull the case. Hopefully then he won't keep banging on about wanting that FOIA answered. Yeah. You got so much power.
Especially when you make it personal and it's literally their livelihood on the line. This is about a little fine. Like they're going to pull it. They're not going to want to tangle. So all Damien's done, if you think about it, again, I see this a lot and we all make the mistakes when we start out. You get into this back and forth with them, arguing with them about what they're saying. So you're almost in a defensive position about what's going on. And Damien said at the start, and this is the way to do it. You just attack for your end goal and you just keep moving forward. And it's that momentum about eventually they realize the spotlight's on them and now they're going to back away because now it's a personal thing. Now it's a problem for them personally. I can't hide behind the school or the council, whatever it is they're doing. It's about them and their own actions. And clearly they're going to pull it. It's not worth it.
You're shining lights on them. I'm now dealing directly with the head of legal at the court. A month before they're even thinking about issuing proceedings against me, I'm shining light on this individual and this individual, assistant head and the team manager. No, it's not your inclusion and attendance department. No, it's you. That is a legal title of office. I'm dealing with you. You're the one that's writing to me. You're the one signing your name to this. Okay. So I'm holding you liable. Now, the other thing is I'm standing on a foundation of truth. And you guys have breached Article 12, right? Protecting my rights and due process. Okay. Right. So I'm not going to get distracted. No, I'm going to hammer this point. You can't do what you're doing. So I'm just going to catalogue all the crimes from A to B: extortion, malicious communications, threats, the coercion. Yeah. Right. My point is this: when I sent the FOIAs, instead of writing 5 in one, it was like, send one. Following day, oh, it's me again. You get the next one. Day later, there you go, the next one. Me again. I know you can't answer these. I know you don't want to answer them. Not looking good for you. So you're hammering them. They're used to putting the fear of God into you, but you do it the other way around. It's understanding their processes. Yeah. So with regards to the Bill of Rights, yes?
Yes.
What did you ask?
So basically, anyone watching this for the first time or now looking to build the knowledge to do this themselves, where are we going to direct them? So we just talked about jurisdictionary. We just talked about Bill of Rights, Act of Settlement, Coronation Oath. What else?
With regards to the Bill of Rights, I've read all the case law that they hide from us. I knew the power in it, just knowing that Boris Johnson, a sitting prime minister, used it in a civil lawsuit as a defense in 2019. Now, that's a sitting prime minister. But come on, that tells you the power of that declaration, of that document. And all your rights are codified within there. So what the law scholars will have you believe is it's not a powerful document. And they'll have you believe that Parliament is sovereign. We are the sovereign. And all power is derived from us. All the power is conferred. The general power is conferred from us. The law scholars in the establishment, for example, this is what I was explaining to her. She was saying in her last video, she was concerned about our free speech being eroded. I said, no, we've got it in abundance. I said, the media are eroding people's perception of freedom of speech. They've been weaponized. So people's psyche perception is that we don't have freedom of speech. You do. It's in Article 12 of the Bill of Rights. They can't breach that. But then the argument that they will come up, parliamentarians or people that can't interpret statute, they will say that Article 9 only applies to Parliament. And I said, no, that's not the case. I said, because if you use the rules of language and interpret it correctly, there's 4 things. There's 4 things being commanded. in Article 9. I said, you do have freedom of speech. I said, it's in Article 9 and it can't be breached. It says that the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or placed out of Parliament. So the establishment would have you believe that Article 9 only applies to Parliament. No, it applies to all of us. Or is a disjunctive or disjunction. And there's 4 commands within that article. That the freedom of speech and debate, that's everyone. That's everyone. Yes? And that's just simple interpretation using the rules of language. The Bill of Rights has a lot more power than people perceive, and that's because they don't have access to the same legal accounts the registered folk, the solicitors, barristers, the lawyers, which I've been privy to. I got access to a justice account, and I spent 7 days reading everything. There's so much case law on the Bill of Rights. I saw the power, but I knew the power was there because otherwise a sitting prime minister wouldn't use it. And that was in 2019. So it's all there. The problem is people are not able to articulate. Everything comes down to a breach of contract, a breach of trust, or a breach of duty, or in this particular case, a breach of Article 1 to 12, 1 to 13, 1 to 14, whichever, take your pick.
On that as well, actually, one of the lessons we've learned is you can't just cite a breach of the Bill of Rights as a generic term. You've got to name the specific article that has been breached.
You've got to be specific, and you've got to evidence how they breached it. It's not enough just to say they breached it, but you've got to prove how. And the communications proved that they breached it from start to finish. So, this is keep those letters coming, guys. Keep those exhibits coming.
This is why you got to, it's played. I always say this, play the game. It's a game. It's all a game of chess. The fact they're doing this in the first place shows you that they're literally committing an illegal act and they're public servants. That is a breach of duty. So if you know that to be true from the get-go, you just got to sit back and let them do what they do. They're giving you all the evidence you need, and then you go do your thing. It's like Damian said, sorry, just one thing is, the reason I'm talking about where to go to learn this is it's the knowledge that gets rid of the emotion that you attach to the situation. And then that turns it from this sort of worrying, scary scenario to something that you can actually have a bit of fun with, because you'll realize way more than these people do. They don't know anything. They're parrots. They only have the same repetitive thing every single time. It's so easy to get around.
You consider that when I got that reply, the Statute Revision Law Act 1948 had repealed the Bill of Rights. Do you remember? I sent the email.
It's funny, wasn't it? It was laughable.
We just laughed.
Yeah.
That was the most ridiculous statement, but that then shows just how ignorant they are. And I just thought this is great. I can really have fun with these now.
Can I just say, just the bit that got me was and you'll know this when you got your own letters, right? Because they said they'd put it to their legal professionals. So the legal professionals are making this comment, which made it even bloody worse. The legal pros don't know shit about the law.
You should sack your legal advisors then, because this is ridiculous. It is utterly ridiculous. There's lack of knowledge, and knowledge truly is power because it takes the fear away. And knowledge truly is power because it takes the fear away. And I was just able to set them up to the point now that they've all run for cover. They've stopped the legal simulation. And I'm slightly gutted because I was hoping that they would escalate it to proceedings in the magistrates' court, because then I was going to ask, when I got the summons for the case file, I'm going to use the disclosure rules and I was going to get the case file and then determine whether they are actually using a bona fide legal proceeding through the court, or do what I suspect that they were going to do, which is exactly what they do with terms of council tax proceedings, where they hire a venue they hire a room within the court venue under the auspice that you don't know any different, and you're foolish enough to go in and then be railroaded through their own private tribunal. You got no right to be there, but this is how you stop proceedings in the first place. Oh, I was going to have more fun with them. You know, here's the case reference number. Under these rules, I would have said to the court, I need all the information relating to this. But if there's no case number recognized, we haven't got anything logged here, you'll have to go back to the council. Then you know that they're doing the old council tax fraud or ruse. And why people aren't suing them for the liability order, which is a defunct, abolished judicial instrument. That's an exhibit. That's evidence alone of fraud and a civil rights violation.
We're going to, just those guys, we're just on that, Damian and I are chatting this through now. We have different approaches to some of the same situations. So we're going to come up with a streamlined approach to council tax and we'll share it with everybody. Okay, so that is coming. But right now, let's get this back to the PCNs. That's a school PCN, but there are PCNs and these fines all over the place, right? If you think about it, what is the magistrate's court for? What does it actually really deal with? It's all this bullshit. They aren't a court. We know that, right? So we're now going to look at how do you apply the same principles to a parking PCN or any other type of PCN. So we've just said it, jurisdictionary, learn how to move the court, as it were. Bill of Rights, Act of Settlement, Correlation Oath, read them, translate them, get your head around that. I would suggest any sort of books you can get your hand on with regards to just constitutional law. It's worth reading and just understanding that stuff anyway. And then you've got, there's other little flicks I'm just thinking off the top of my head now. You've got because just on how they try and rebut you and get you out of your box, you've got the metric martyrs judgment that confirms that the Bill of Rights is a primary statute. And then you've got the thing you mentioned about the Transport Committee in Parliament confirming that they're just fines, because that's a really cool thing.
Yeah, because
you can search that online, by the way, guys. It will be there. Just it's on.
It states specifically that basically they're using semantics. It says, you can call it what you like, that they said, no, the actual term is, it's a clever play on words, a penalty charge notice. But what we are actually dealing with here is a fine. And this is the Parliamentary Committee on Transport. I think it's 2009. You can find it. If you Google that now, you'll find it. It states clearly there. And that's your back. That's supporting evidence. Look, this is what we're dealing with, a fine. And this is in breach of Article 12 of the Bill of Rights, no fine or forfeiture before convictions. And it is my understanding that you as a private parking company are not a court of law. So why are you fining me?
It is that simple, right?
It's simple.
Because one of the things they might come back and say is, because where the Bill of Rights says conviction, they'll go, oh, no, this is a civil matter. So they'll refer conviction to, and this will come back from the legal pros, conviction meaning this is criminal, this referred to criminal matters. This is a civil matter, so it doesn't apply. So this is they want to get you out of your box, just bring it right the way back to your box. That one line is everything, okay? Because the Bill of Rights supersedes all others. So they can't use the Traffic Act as an example. Sorry, go on.
You just bomb your account and the bank, someone provide me evidence of that then, please. That's it. You're standing in square. Okay, provide me evidence of that.
Just actually one note, I've done that once, just to say that, and it all came to a halt. So that wasn't even going anywhere close to what Damian's just done there to do what he's done. Just this is a great way to just start your journey out anyway, right? Because, okay, Damian's done a lot of reading, a lot of doing. So you're not going to get there from day one, but it doesn't mean you can't do stuff from day one. It doesn't mean that you might have read the Bill of Rights today, understood that one sentence and just started using that, holding them accountable to say, hang on a minute, isn't this illegal under this section? And then the game starts anyway, because they're going to reply to you. So that's just a great way of learning and leveling up, isn't it? Just get into interaction with these people. Don't be scared of the situation.
Totally. This will stop when everyone makes it stop. Look, I can't put this any better. What are you prepared to suffer?
Yeah.
You get what you are prepared to suffer. I'm not prepared to suffer any of it. And I feel inordinately free because I had the knowledge to deal with this without any worries. And when you get bored of dealing with the PCNs, because you've got to be very persistent, certainly with the traffic companies, they're very mind-numbing. I find it easier dealing with the councils, especially when you're hitting their indemnity insurance. So there's a three-prong attack there, but that's knowing their Achilles heel. That's holding them liable. That's understanding the law, how to evidence what I'm saying and articulate it in the correct way. That's cataloguing their crimes from point A to point B. And it's also providing them evidence I know how to access the court. I know how to flip the court to the correct procedures. I know what's going on, and I know how to control the court through the rules and procedures they're bound by. It works both ways.
That's exactly it. And it's just that knowledge. That's the journey of you're all like last week you learned some things, right? It's this the thing. It's always about the continuation of the learning and the studying and the doing. And it's not until you get into doing that and you're face to face with these different people that you really get the lessons, that the understanding of what you need to do and how you need to play the game. You've got to put yourself in amongst it. Otherwise, there's no point. So don't. What's the word I'm looking for? I think Gary Vaynerchuk that said something like this, like you can't be half pregnant. I'm not being sexist or anything like that, but it's that saying that you're either all in and doing it or you're not. You can't pussyfoot around on this stuff. You go all in, you're committed, you go for it. That includes the studying, everything you need to do with it.
What I would say, you're always learning, and I'm helping Council Watch with certain litigation, and I'm reading now a lot of legislation I hadn't touched or had the need to touch before. And again, finding some brilliant nuggets with regards to holding our public servants to account. At the end of the day, the legislation is there to limit their governance, limit their power.
Yep.
Okay. You've just got to find the necessary legislation to either prove a breach of duty with regards to what they're doing or to limit their power. Actually, you can't do that. This is what you should be doing because it says so here. It's in the black and white letter of the law. The legislation binds you people. And that's what legislation's for. Just remember, the law is the law is the law.
It's true. And that means your remedies are out there, guys. They're out there. It's not so dystopian. It's not the way that I think things are being projected or portrayed. We do have the power, and it's really about each of us individually first comprehending that and then doing something about it. It's all well and good. Oh, yeah, I know the Bill of Rights, blah, blah, blah. But if you're there continuing to pay into this system that is actually trying to kill you and your family, I think there's a question you want to be asking yourself, right? So one thing knowing it, the next thing doing it. And we need everybody doing this stuff because we're all in this stuff together. So I think on that note, Damian, thanks, mate. And we'll see you on the next one.
See you later. See you guys.
Ever grappled with the labyrinth that is the legal system? It's a maze of jargon, procedures, and power plays that can stump even the most intelligent among us. Enter How to Win in Court, a transformative course designed to level the playing field. Brought to you by the dynamic partnership of Sovereign Empowerment and Dr. Frederick Graves. This course is like a compass, guiding you through the intricate passages of the legal system. It provides powerful case-winning strategies and tools for controlling solicitors and persuading judges. This isn't just about understanding the law, it's about empowering you to use the law to your advantage. This comprehensive course eliminates guesswork and empowers you to navigate the legal landscape with confidence. Imagine having step-by-step instructions at your fingertips, demystifying the complex world of court cases. With How to Win in Court, that's precisely what you'll get. There's a treasure trove of sample forms, video seminars, audio clips, and comprehensive classes waiting for you. Finally, you'll have all the tools you need to persuade and control judges in any case or court. The beauty of this course is its accessibility. Whether you're an early bird or a night owl, you can dive into the course material anytime with round-the-clock online access. And no matter the device, be it your smartphone, tablet, or laptop, you'll have seamless access to the course. You'll also gain access to invaluable tools like the free online legal research tool, legal dictionary, and a Q&A forum. Learn from a seasoned attorney with over 40 years of winning experience who has distilled his expertise into this comprehensive program. These resources are like having a personal legal advisor, always ready to assist you, but without having to pay exorbitant legal fees. For those struggling to afford a solicitor, this course is a beacon of hope. Good people have suffered too long at the hands of power because they didn't know how to fight back, or they didn't have access to the right resources. Now, in a matter of just a few days, you can acquire the tools and the knowledge that it takes law students years to achieve. With the right knowledge and tools, you'll be able to navigate the legal waters with confidence, winning your case without expensive legal representation. Alternatively, if you already have a solicitor, you can equip them with the tools and tactics to fight effectively on your behalf. Level the playing field and secure your victory. And the cherry on top? Upon course completion, you'll receive an honorary law degree, a testament to your newfound legal prowess. No matter what court, civil or criminal, you'll be able to conquer any courtroom challenge with ease. This step-by-step guidance ensures a quick and straightforward learning experience, empowering you to navigate the legal system with bulletproof confidence. That's right, the power to navigate the legal system is now within your reach. All it takes is the will to learn and the courage to empower yourself. Everyone deserves access to the right legal knowledge. That's why we offer the jurisdictionary law course at an unbeatable price. For less than the cost of a 1-hour legal consultation, you'll gain unlimited access to this complete program for up to 2 full years. Take control of your legal battles without breaking the bank. So why wait? Enroll in the jurisdictionary course today and take that first step towards legal empowerment. How to Win in Court has become the most trusted law course worldwide for almost 30 years. Don't miss out on this exclusive opportunity to gain the upper hand in the courtroom. Your journey to mastering the legal system starts here. When you have access to the right resources, you will become a force to be reckoned with in any courtroom. So click the link now to become empowered with all the information you'll ever need to know how to win in court. Learn how to use the court system that is there to protect you, your family, your property, and most of all, your rights.